Hey, I'm Gary.
And I'm David.
And we just want to take a moment to let you in, if you hadn't heard, on what happened in Kentucky and why it is so meaningful for us here in Tennessee. And what happened is a 2017 law in Kentucky. It was their ultrasound law. And I'll let David explain some of the details, but basically that law got struck down by the district court. On appeal, it was upheld by the Sixth Circuit Court of Appeals. And what happened this week is that the Supreme Court refused to hear the appeal of this bill from the Sixth Circuit, which essentially means that they have upheld the ruling of the Sixth Circuit. And that is really significant for our abortion bill here in Tennessee coming up in 2020. David, tell us why that is.
Yeah, it is. You never want to try to guess what the Supreme Court is meaning or saying necessarily when it decides not to hear an appeal. But what it did do is it left the Sixth Circuit's decision as the interpretation of the Constitution relative to abortion in place.
Right.
And Tennessee's part of the Sixth Circuit. So if we pass this new bill, and just for a little bit of history here, in April there was this heartbeat bill that had passed through the legislature, got to the Senate, SB 1236. And we had an amendment to it that sort of rewrote it. And it still kept being called the heartbeat bill, but they deferred it to a summer study committee. The Senate Judiciary Committee had 2 days worth of hearings.
That happened in August.
And we were asked, rewrite this rewritten bill and give us the strongest, best thing you can. So we've done that. We provided it to the chairman, the members of the committee, and to the sponsors, and said we would recommend to you what we're calling the Rule of Law Life Act. And we would propose that it just be a whole separate bill. Don't try to amend it and get people confused or out for the heartbeat bill or the Rule of Law Life Act, or they the same thing or not. Just stop thinking about a heartbeat bill and think about the Rule of Law Life Act. Now the big question is, well, is that going to be constitutional? Well, we don't know. I would just tell you flat up, everybody would tell you, you'll probably lose in the district court.
Right.
I mean, they lost in the Kentucky law. But the Sixth Circuit upheld it. And that's where we have to go through first before we can get to the United States Supreme Court.
The same Sixth Circuit that upheld Kentucky's ultrasound law, which was considered fairly controversial, is the same court that would hear our case on the Rule of Law Life Act.
That's exactly right. Now, people need to appreciate this. I don't want to misrepresent what the Sixth Circuit did. The case was by abortion doctors, but the argument in front of the Sixth Circuit was that this is a violation of the First Amendment because it's government-compelled speech. You're making me say things that I don't want to say relative to the abortion. So what was the law? The law said, well, you had to do an ultrasound, and then you had to allow the heartbeat to be heard and offer to the woman the images. If she didn't want to see the images, you had to offer to read to her while they're hearing the heartbeat what you see on the images, that their fingers, their toes, there's a heartbeat, there's organs, there's a kidney now, or whatever it might be. And of course, the woman had the freedom to say, I don't want any of that. But that was the law. And so they said, this is unconstitutional. It is a violation of our First Amendment rights to not be compelled to say things as doctors. And the Court of Appeals, Sixth Circuit, upheld it and said, well, we regulate doctors lots of times. We have informed consent laws for everything.
New.
Yeah, this isn't new, informed consent laws. And they're just trying to make sure you say certain things that are true. So the question is, are the things you're saying true? If they're true, then what are you complaining about?
And here the Sixth Circuit is saying they most certainly are.
They said what you said in that abortion law is true. It's conveying true information. So that's why it's important to us, because we want to say, okay, what has the Sixth Circuit said is true about abortion that we can then extrapolate and say, well, it should be true about our bill too.
So let's talk about some of the things they were saying and why it's important. Yeah. So 30 times in the first 17 pages of its opinion, the circuit court used the terms unborn child or unborn life.
Right. And here's why that's important. The last really positive pro-life ruling we have from the Supreme Court where they upheld the law was another very controversial law. It was the partial birth abortion ban, the federal partial birth abortion ban. And in that case, a majority of the judges wrote an opinion upholding that law. It was actually authored by Justice Kennedy, who's not on our side on this thing, but he upheld that law. He's now gone, replaced with Kavanaugh, who is an original intent kind of judge. And what they said in the Carhart case, and this is what's important about Carhart, and because again, they upheld the law, but the people who are opposing the Rule of Law Life Act, if you listen to their testimony, they don't really talk about the Carhart bill. Why? It doesn't fit their agenda. The Supreme Court won't do the right thing. So let's just kind of ignore that. Still a valid decision. So read to folks what Justice Ginsburg said. Now, you need to appreciate Justice Ginsburg. She's radically pro-choice.
Right.
And she writes a dissenting opinion in Carhart, and she just goes off the wall against the majority. So read what they said.
Yeah, she says the court's hostility to Roe, or to the right Roe and Casey secured, is not concealed. Throughout the opinion, a fetus is described as an unborn child and as a baby.
Yeah, I mean...
we can't call this a baby.
Yeah, she's saying, when you start doing things like that, and she said, you've also talked about moral considerations and medical ethics situations. I mean, how much longer is abortion going to stand?
I think it was a Planned Parenthood case. She mentioned that if we're going to be all moral about this, how long can the right afforded by Roe actually stand?
Sure. Yeah. But the important point about this is the Sixth Circuit is saying this is an unborn child, and they can look at the Supreme Court and say, well, that's what a majority of you called it. So at least I'm thinking right. We're not thinking two different planets here. Mm-hmm. Then the Sixth Circuit said something else was true about abortion.
Yeah.
That relates to Carhart. So
they begin saying abortion involves a human being. So they quote the Eighth Circuit in this ruling, and they say that the abortion will terminate the life of a whole, separate, unique, and living human being. And the law defines a human being as an individual living member of the species, including the unborn human being, during the entire embryonic and fetal ages from fertilization to full gestation. So the court is firmly acknowledging that they see a living human being, separate whole, separate from its mother.
It's not just my body.
Right. From conception, from beginning to end, that is a living human being.
Right. Now, I want to again make sure people understand what happened. So the Sixth Circuit is looking at this ultrasound law, heartbeat law, and they're saying, well, has anybody else looked at informed consent laws that have upheld them, and how did they do it? And how did they uphold them under First Amendment challenges? And so they cite this Eighth Circuit case. Say the Eighth Circuit said this about their law, and here's what they said about their law, and they said this is truthful information. So as long as we're talking about truthful information, and therefore it's okay, well, by analogy, then we're okay. So they're looking for support to say, where else is a court?
They're sort of looking for some sort of precedent that this has been said before.
As somebody else said, if information's truthful, and so the Sixth Circuit quotes this, and here's what's important. During the debate against the Rule of Law Life Act, the opposition said the test, doesn't matter, is viability, viability, viability. Can you survive outside the womb? If you disregard that principle, if you have a law that disregards that principle of viability, of living outside the womb, then you're sunk. Well, what did the Eighth Circuit just say? From inception, it's a human being, and it's separate and distinct.
From the moment of conception, from fertilization, there is a viable human being in the womb.
That's right,
and we acknowledge that.
That's right. Now, that ties into Carhart.
Yeah.
And again, the majority says something, and Justice Ginsburg has a hissy fit. Now, read what she says about the majority, and she's actually quoting it. But here's why she didn't like Carhart. Again, the other side doesn't want to talk about Carhart, but what does she say about Carhart?
Yeah, she's saying in cases on a woman's liberty to determine whether to continue her pregnancy, the court has identified viability as a critical consideration. Today, the court blurs that line.
Did you hear that?
Yeah.
Everybody says, Fowler, you can't be right. You got viability is the gold standard. And she says, well, that's what it used to be. But today, you just blurred that line.
Yeah, the court, in and of itself, is struggling to understand what they really mean by viability.
Yeah. So, well, they're saying that's not the determinative thing all the time because you just blurred the line. Now she finishes the statement.
Yeah, she says, maintaining that the act legitimately applies both pre-viability and post-viability because a fetus is a living organism while within the womb, whether or not it is viable outside the womb.
Yeah, it's a living organism.
Yeah, it's viable now.
Whether it's living as... So she's saying you just blurred the line. You've put at issue this, how really critical and determinative in every instance is this viability standard. Okay? So the Sixth Circuit can say, oh, good, I'm looking at this as a whole separate living being from conception, and that's what the Supreme Court says. And how do I know that's what the majority is saying? Is because that's what Ginsburg accused them of saying, and she's quoting them.
Yeah.
So, okay, good. We're now thinking alike in two different ways. That's good.
And again, just as we kind of proceed with this, not that we can put words in the Supreme Court's mouth necessarily, but you kind of have to infer, right? I mean, the Supreme Court is seeing all of this language coming from the Sixth Circuit, and they decide not to hear the appeal. They decide not to hear the case. They decide to allow that to stand.
And the Sixth Circuit is using a language the Supreme Court's used.
Yeah.
Okay. Now, there's one last thing the Sixth Circuit did that I think is really, really important. And if you read what the court said there.
Yeah, so really attributing to an unborn child that it's a person, the court began to talk about the relationship between this living human being and the mother.
This is the Sixth Circuit.
Right.
They're again quoting the Eighth Circuit as being true.
So they say that the pregnant woman has an existing relationship with that unborn human being, and that the relationship enjoys, this is huge, that relationship enjoys protection under the United States Constitution and the laws of South Dakota, which is where the Eighth Circuit was hearing this particular case. Right. And that by having an abortion, her existing relationship and her existing constitutional rights with regards to that relationship will be terminated. So it's interesting that the court is firmly acknowledging that there is a relationship that needs protection from the U.S. Constitution, but you could see the pathway they're taking, but they haven't taken the full measure yet in saying that this living human being that they've acknowledged is inside the womb is deserving in and of itself of constitutional protection, that it's a constitutional person. But they're kind of building a bridge to that, because here they're saying, well, the woman and this living human being is in a relationship, and that relationship deserves protection under the Constitution.
Sure, but think about it. A relationship is not what you have with things.
Right.
You know, I have a relationship with this wall or my shirt. I own things. I possess things. I have relationships with living beings. Now, that's a critical distinction, because they're saying this is a relationship. It's not a relationship of ownership of things or just possession of things. It's a whole separate thing. Well, you can have a relationship maybe with your dog or your cat, but that's not a personal relationship. That's a person-animal relationship. So since we've acknowledged this is a human being, it's separate and distinct from the mother, it's an unborn child, it's another, this is a personal relationship, isn't it? You have a personal relationship with your child. Mm-hmm. Well, if that's the case, then it's a person to a person.
Right.
The baby, they without saying it, they've acknowledged this is a person.
Well, because you could
have
argue,
a relationship with
you could argue that if they're saying if the relationship is protected by the Constitution, and the Constitution protects persons, then it certainly seems they're saying that both of the human beings in this relationship are both people.
Yeah,
but you can kind of make that leap.
Because otherwise you wouldn't have a personal relationship.
Right.
You'd have an ownership relationship.
Yeah.
You'd possess something. Okay. And so that's really important. So what I want to say, if I were to put this in a scriptural biblical context, where Paul in Romans says, it's not that we don't know the truth, but in our unrighteousness, we suppress the truth. I don't want to hear that truth. So what the Sixth Circuit is saying, well, it's an unborn child. And the Supreme Court said, yeah, it's an unborn child. It's an unborn life. Well, it's a living human being from conception to birth. And the Supreme Court saying, yeah, it's a living being from, okay, good. We're thinking along the same line.
Yeah, we're tracking.
And now I'm saying it has personal relationships, which means it's persons. Did you realize what you just said? See, once you let that in, Roe versus Wade crumbles.
Right.
Because the 14th Amendment protects the right of persons to life, liberty, and property.
Right.
So the Supreme Court has been dropping those breadcrumbs, and they don't, all of a sudden they've realized they're up at the wicked witch's house, and oh gosh, what am I going to do with Roe versus Wade now?
And they continue to do it. They did it in 92 in Planned Parenthood. They did it in 07 in Gonzales, and now they're doing it right now.
Yeah, so, and the Sixth Circuit's picking up these breadcrumbs, and now they've said this really is a person, because it's a relationship. And so my thought with the Rule of Law Life Act, if people want to understand what it means, is leave the 14th Amendment over here and just acknowledge the Supreme Court is refusing to tell itself the truth. It's refusing to believe what it already knows is true. It's really acknowledged it's true. It just doesn't want to make the final connection. Mm-hmm. But the Sixth Circuit kind of already implied that. So go to them under the Ninth Amendment and say, hey, Sixth Circuit, you know this is an unborn child. You know it's separate and distinct from the mother. You know it has relationships with the mother. You've experienced when you've seen a woman lose her child before it's born. Shouldn't go like, well, it's like taking out the trash. No, because there's something going on here. There's a bonding taking place. I've seen it in my own family, not with my wife, thankfully, but I've seen those things in my family relationships. And so the idea is to say, so here's what we're going to do. We're going to say the Ninth Amendment says that you cannot construe enumerated rights, like the 14th Amendment, Second Amendment, Third Amendment, Fifth Amendment. You can't construe those, quote, to deny or disparage other rights retained by the people. That's a clear acknowledgement that all of our rights don't come from the Constitution. There are other rights. Mm-hmm. Just because I spelled these out doesn't mean that I don't have these.
Yeah, there's natural law. There's common law.
That's right.
That does in and of itself a really great job at defining what persons are if we will just go back to it.
If we will just go back to it. And so let me put in a plug for our podcast of the recent weeks where we've been talking about natural law, common law, and how they relate to this. Yeah. God, law, and liberty. People ought to watch it. But the point is here, the common law says, well, one of the three great rights is life, liberty, and property. Well, isn't that surprising? That's what you find in the 14th Amendment. It's what you find in the Fifth Amendment. But the common law said when it comes to life, there's an absolute right to life, and it includes the child in the mother's womb, and we treat it as if it is a born being for property law and tort law, injuries and so on and so forth. Yeah. And that's true. In every area of law, we treat the unborn as if it's a person and a human being, except abortion.
Except for abortion.
Yeah. We've carved out one exception. And so we're going to say, the Ninth Amendment says we retained rights. The state of Tennessee, on behalf of the people who retain those rights, is going to secure them. Now here, Sixth Circuit, you know the truth. Don't lie to yourself and say, I'm going to uphold this law as a valid response under the Ninth Amendment. And if that creates a conflict with the 14th Amendment and your messed up understanding of persons, then Supreme Court, you can hear the case and decide it.
Yeah.
But that's what we need to do, folks. It's time to stop dancing around the edges,
Yeah, so for those of you who are out there and you're following this and you've been following SB 1236 and you're following what's happening now coming into 2020, be prayerful, be mindful, and understand, like David's saying, how important it is what they're saying from the Sixth Circuit in regards to this Kentucky law, and especially the fact that the Supreme Court chose not to hear the case. But last thing, you mentioned this, which I love, the fact that to convince ourselves that this is not real or not true, the truth is written on our hearts, and we have to do the daily work of lying to ourselves and suppressing the truth, because we know what's in the womb, right? And I love the way Dr. Randy Davis in the summer study in
with
August,
Tennessee Baptist Convention,
ended his testimony to the Senate Judiciary Committee. He's like, look, we all know what we know. We know the truth here. And he just kind of looked at him and he said, what will you do with what you know? Yeah. And that is the critical question, I think, moving forward into 2020. Here's all the things we know. Here's the things that the Sixth Circuit clearly knows.
They certainly are truthful. That's why I can make you say them.
Right. What will we do with what we know?
That's right.
Thanks
have a great Christmas too.
Yeah, and check out God, Law, and Liberty, Apple Podcasts, Spotify, anywhere you listen to podcasts. Check it out. David's got some great wisdom in there.
Great.